I'm just going to go through the changes to benefit entitlements to EEA migrants. I've given around a handout which has got the information that you're going to see on the slides in probably a little bit more detail, so if you can follow that if you want to, or just follow it on the screen. At the end, there's kind of going to be a little bit of time if you guys have any questions, or also if you have any kind of practical examples you want to share, because for someone like me who works in policy, like a large part of what I do is working out how these things are supposed to work in theory. But often we find that maybe in practice they don't work like that particularly, and this is especially the case with things that are as complicated as benefit entitlements. So I think it's important when we're talking about benefit entitlements for EEA migrants to kind of understand the political context. And the reason for this is actually because, as you'll see later on, a lot of the changes that are happening, it's quite ambiguous as to how they're going to work in practice. And the best way to understand that is to understand why these changes are being brought in. So just to give a few examples, on the 1st of January, transitional arrangements ended for Romanian and Bulgarian nationals. Conservative MPs, there's been a backbench revolt recently, which I'm sure some of you may have heard of, where they've asked that these restrictions be imposed for a longer period of time to 2018. And then also, according to the latest ICM polling report, 11% of those people surveyed said that they were intending to vote for UKIP at the next national elections. There's also other things that you can talk about. So there's the continuing press from Conservative MPs to renegotiate EU treaty rights. George Osborne's kind of continual focus on benefits as an electoral strategy to kind of counteract Labour. And then also, in a more general sense, the kind of, I use the term centralisation of benefits in terms of things like Benefit Street, or I don't know if any of you saw the Channel 5 documentary the other night. These are the kinds of things that we're talking about when we talk about benefit entitlements, both generally and both for EEA migrants. So when we look about how this has had an actual practical effect on public opinion, the EU has consistently asked the UK government to provide evidence that benefit tourism is a problem. The government, on a repeated basis, have actually said the reason that they're implementing these changes is not because they have any robust empirical evidence, but because there is a public perception that there is a problem with benefit tourism. And that quote there is actually from a BBC article, which was from a leaked memo from a Conservative Party. And again, the way that I said this is affecting the opinion of the general public. So according to a survey that was reported in The Independent today, which was run by Ipsos Mori, the majority of people believe that 31% of the population is made up by new migrants, when the actual figure is only 13%. So these are the kinds of effects we're seeing on public opinion. So as a result, the Conservative Party, in bringing in these types of changes, it's potentially more about being seen to be doing something than it is about implementing actual changes to the system. So from December last year, the government has imposed a number of these changes. However, some of them we know what it means in practice, and some of them we don't. And that kind of distinction I'll draw a bit more clearly later for you. But I think when we're talking about the changes, the best way to understand them, or the way that I have found the most helpful to understand them, is via the habitual residence test. Now, I'm sure some of you, or probably the majority of you, have come across this or know what it is, so I'm sorry if I'm covering sort of old ground in this particular slide. But the HRT, what it is it's a test that's administered to establish the eligibility of migrants, and also importantly, UK nationals who are returning after a period of time away, to see if they are able to receive social assistance from the state. Now, in its most basic form, the test has two parts. The first part is the right to reside, and the second part is the actual habitual residence. Now, it's important to note that you have to be able to pass the first part to even be considered for the second part. So talking about the right to reside, so what we mean by that is that it's whether someone is in the UK legally. Now, sorry, do you guys want to... It's all right, just grab a seat. So when we're talking about legal rights to be in the UK, all migrants from EEA countries have an unconditional right to be in the UK for at least 3 months. Everybody has that right. So to have a right to reside after 3 months, individuals must either be considered to be permanently resident or qualified persons. And I've kind of detailed in your handouts what those qualify, but permanently resident generally means that you've been in the country for at least 5 years, you're married or you're a family member of someone who has permanent residence, you were working here and then have retired. things like that. Whereas a qualified person is more someone who's signed on to a job centre and is looking for work, someone who is in work, or a student. So the second part, so once you've passed that first section, once they've established whether you're either permanently resident or you're a qualified person, you can take the habitual residence part of the exam. And what this is intended to do is basically to establish whether someone wants to make the UK their home for at least the time being. Now this is kind of difficult to establish because the term residence is not actually defined in law, but there are certain questions that are likely to be asked. So is the UK the applicant's main centre of interest? Is there a job market for them? Do they have family members here? Are they intending to stay for a long period of time? Things like that. That's what we're hearing are the types of usual questions. So now moving on to the reforms. So the first one that was introduced was what's been termed an improved HRT. Now what they mean by that is that there are going to be more specifically tailored questions in addition to the ones that are already being asked. And these tend to be focusing more on people's language skills and their efforts to find a job in their home country or wherever they were previously resident. The second set that were introduced, the first thing was that what they're saying is that no EEA migrant can apply for out-of-work benefits. So what we mean by that typically is job seekers allowance for the first 3 months of their stay in the UK. The second one is that what they're saying is even if you are a qualified person and you have previously been claiming job seekers allowance, once you get to 6 months, you will lose your qualified status and therefore will no longer be eligible for job seekers allowance. So that's essentially a 6-month time frame on claiming out-of-work benefits. And then the last one, I'm going to talk about this a little bit more. It looks quite frightening at the moment, but as I'll explain later, it's probably not quite as serious as maybe that implies, is that if EEA nationals are caught rough sleeping, then they can be subject to administrative removal from the UK and then banned from re-entry for 12 months. The last reform is that there was a press release, I think, the other day from the Department of Work and Pensions with very, very limited amounts of information on it. But what they've essentially said is that new EEA job seekers will no longer be able to access HB if they are claiming income-based job seekers allowance. Now, this is probably one of the worst worded pieces of legislation or potential pieces of legislation that I've ever seen. And I'll explain why, again, we're not really sure how this is going to work a little bit later. But as I was saying before, the best way to understand these changes is to think about the habitual residence test. So different parts of these reforms will affect different elements of the habitual residency test. Some of these changes, as I said, we can kind of predict maybe what will happen, again, in theory and in practice. And some of the parts, such as that one in April, we really have no idea how it's going to work. So the effects we can predict. So the right to reside. This section of the habitual residence test is probably going to be affected by the stipulation that newly arrived migrants cannot claim out-of-work benefits for 3 months of their stay. So, in theory, because everybody has an unconditional right, if they are a member of an EE state, to travel across other member states and be there for 3 months without looking for work or without claiming benefits or anything like that, in theory, they could pass the right to reside element of our habitual residence test. What this reform does is it takes that away. So although an EEA migrant who is newly arrived here has a legal right to be here, they will not be considered to have a right to reside for the purposes of the habitual residence test. So therefore, they won't be able to pass that first section and move on to the section where people look to establish whether they're looking to make the UK their home. The second one is going to be, is affecting the classification of qualified persons. So this is going to be affected by that time limit that I talked about earlier, where EEA migrants who are out of work can only claim job seekers allowance for 6 months. And what this means is that they'll lose their status as qualified persons. So when they first started claiming benefits, they'll have passed the habitual residence test, they'll have been put onto something like job seekers allowance. If they haven't been able to find a job, there'll be a review at 6 months, and unless it's established that they have a genuine possibility of finding work, and again, how they're going to establish this, we don't really know, then they will be removed as a qualified person and won't be able to claim job seekers allowance anymore. Now, some of the changes that we aren't really sure how they're going to work in practice. So the improved HRT, so the habitual residence test as it stood before January was applied in different ways, because obviously everybody who applies has different circumstances, and therefore there's not an objective set of questions that are asked when they apply for these types of benefits. So what it was advised, or currently what we advise people to do in helping applicants provide as much evidence as possible, is to help them get certain pieces of evidence together. So identification, evidence of their time of arrival in the UK, legal work undertaken, what they were doing previously before they came to the UK. The improved HRT, as I said earlier, the questions are going to be more personally tailored, but there's going to be a heavier focus on language skills and efforts to find work prior to coming to the UK. So whatever evidence you can help people provide around those types of questions is going to be able to help them. But this is essentially what they're talking about when they talk about the improved HRT. Now, access to housing benefit. Now, the reason that we know very little about this reform is because there's no legislation for it. It's not due to come in until April, and it's only just been announced as officially happening a couple of days ago. So, you know, it's not on the internet anywhere. As I said, we've generally got no idea. What I suspect it means, and again, this is just my guess, so don't take this as gospel, is that HB will be restricted in the same way as out-of-work benefits for new migrants. But the way they've actually worded it is really, really confusing, because the way they've said it is that no one who is currently receiving income-based job seekers allowance will be able to apply for housing benefit. Now, both of those benefits are income tested, but the reason it's strange is because what they say at the moment is that the habitual residence test will not apply in the same way to job seekers allowance as it does to housing benefit. So they're two separate tests, and that's largely because they're administered by two different authorities. One centrally, job seekers allowance by the job centre, and the other one, housing benefit by the local authority. But the way they've worded the statement makes it seem that if you are receiving job seekers allowance, you will automatically be excluded from housing benefit, which, as you can kind of see, is a complete contradiction of what is already in place. The term new migrants is also very complicated because we don't know what that means. Does that mean newly arrived migrants? Does that mean migrants who have only just lost their job? So there are questions around that, essentially. And the final one, the administrative removal. And the reason I said this probably doesn't look as serious as it first seems is because the border agency, which they're not actually called the border agency anymore, they're called like the Home Office Immigration Enforcement Team. They already possess this power. They already possess the power to administratively remove people. There's been some slight changes in the process where they do this. So what they do originally is if they're supposed to find someone who's rough sleeping, they're supposed to issue them with a letter which provides them with their intention to remove them. After that, they have to have an interview, and then after that, they have to agree to it. What they've said, and this was prior to these reforms, is that if they know that someone is definitely rough sleeping and does not have a job, they can skip that stage where they give them a letter. But again, we don't really know how you're able to establish this other than asking someone, essentially. So it's difficult to see how this reform actually changes their existing powers. Now, the section that says that people will be barred from re-entry to the UK, I'm pretty sure that once this comes in, or we see cases of it actually happening, there'll be a legal challenge from the from the EU court, essentially because it's in breach of treaty rights. Because of freedom of movement, you essentially can't impose these types of restrictions under EU law. So again, I have no idea how they intend to make this work, but I'd be very surprised if they actually manage to make it work in the way that they've pitched it as it stands.